This one is for all my people with treaties and without treaties, doing business publicly and privately. I, self-law and master. Greetings, love, truth, peace, freedom, and justice. Honest and respect to all prophets and messengers that have come this way before me, done this work, set a path for me to follow. All right. Today's research segment will be on the Fair Debt Collection Practices Act, in which we're dealing with consumer financial violations. All right. Consumer credit disputes, and more particularly, disputes regarding credit. What else would it be? So, whether you've been credited for a credit card, with a certain quantifiable amount on it, or a loan for educational purposes, or a loan for the acquisition of houses, or credit for businesses, or any of the aforementioned purposes. This video, I hope you go get a piece of paper and a pen. You might need it. And help a brother out. I'm trying to hit 50 likes, just 50 likes. So don't forget to hit the thumbs up button. Send this video, with the intention of to a friend that they are going to also give this video a thumbs up. We're just trying to reach more people with this information. All right. A lot of people would not be interested in certain forms of spirituality had they not been physically or commercially affected and violated, which leads them to start pursuing other forms of remedy. Once again, sometimes that remedy comes in the form of spirituality. Other times it comes in the form of civil action. All right. But either way, let that sovereign conscience be thy guide. All right. So we're going to start off with a couple of things. First off, we're going to start off with the United States Constitution. Yes, I know I'm not starting off with the United States Treaty of Peace and Friendship that it held with Morocco. I'm going straight to the Constitution. And then for those of you who are actual, national citizens of, Morocco, your government may need to be getting involved in order for there to be some type of dispute held within the proper venue, which it would be on an international level. But, for those of us who are not on an international level, you're disputing things from a federal perspective. All right. And let's just start off here with this U.S. Constitution. All debts contracted and engagements entered into before the adoption of this Constitution shall be valid against the United States under this Constitution and as under the Confederation. Those who are not familiar with the Articles of Confederation, perhaps you may want to review that information. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. So, for an individual who might be undergoing some type of consumer credit dispute with an entity that is engaged in the business of extending credit, well then, understand that, like, if that quasi creditor actually does file any suits against you within the state, it should not be within a civil or a county court. It should be at minimum within the state court. All right. And the reason why, or more specifically, it should be a state court that has been authorized by the federal government to hear matters that are of a federal concern. For example, and we'll get into that in just a second, all right? The senators and representatives before mentioned and the members of the several state legislators and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any public or public trust under the United States. And that's just clarifying for those who may think that, yes, while, certain portions of literature may state that one nation under God, the U.S. Constitution does not require or does not make any form of religious test to confirm or deny whether or not an individual holds such beliefs, but that their word be taken in the presence of whomever is making such oath of their creator. Well, then that's where, the religious aspect does come into play, and the ethical, aspects of jurisprudence or, commercial ethics comes into play. All right. So, your state or your county courts people are not really, authorized or even empowered to hear such matters. They have to get that authorization, that delegation of authority from the federal, district courts. All right. And a federal district court that is within your region being whatever state, territory, it is that you may be within the continental body of the United States corporation. All right. Moving right along. Let's go ahead and address something else. Civil liberty. All right. Because most people are just trying to understand like how to go about filing their or where to start as far as their damages go and how to calculate such things and then how to support their claim to such damages. All right. So Title 15 United States Code of Law, Section 1640, Civil Liability. An individual or class action for damages, amount of award, factors determining amount of award. Except as otherwise provided in this section, any creditor who fails to comply with any requirement imposed under this part, including any requirement under Section 1635 of this title, subsection F or G of Section 1641 of this title, and for those who have not already reviewed Section 1641, that would be the Fair Credit Reporting Act, or Part D or E of this subchapter, with respect to any person, is liable to such person in an amount equal to the sum of, number one, any actual damage sustained by such person as a result of the failure. So, deprivation of property, however much the property might be appraised for, that's an actual damage, especially if the individual has been deprived of their property through some form of unlawful mortgage foreclosure. Like you may not have been able to get your justice within the civil court and a mortgage foreclosure, but sometimes they actually do have it in the Supreme Court, and even still in the Supreme Court, the states have agreements with a lot of these commercial entities, so they're already engaged in business, and the court's already going to get their piece of however much it is that the usually the bank as plaintiff is filing. But my recommendation is to simply, since this is a federal code or a federal act, the Fair Debt Collection Practices Act. I'm a little excited. That's all was happening on my end. The Fair Debt Collection Practices Act is a bill that was passed through legislation and double checked through the executive offices for its recognition or its mandate to be made a law, in which case the FDCPA, the Fair Debt Collection Practices Act, was an act created to protect consumers from fraud being committed by a lot of these commercial entities. All right. Section 2A, in the case of an individual action, twice the amount of any finance charge in connection with the transaction. So, if and usually the sum of in regards to like foreclosures or even like vehicles, or even when it may come to with children, as being wards of a state, well, the value of those art parcels of property exceeds $75,000, and there can always be a conflict of interest regarding the court and as a state entity doing business with a foreign private corporation. So, but these are matters that maybe you as an individual who's curious might want to bring up to a lawyer, because this, ladies and gentlemen, is for educational and informational purposes only. I'm not a lawyer. I do engage in the business of credit resolution for members of my organization, and yes, membership petitioning will be available in September. So for those of you who might be interested, don't forget to send an email with your interest and preparation for membership package for the month of September. We won't be doing anything before the month of September. All right, so just hold on. Fair Debt Collection Practices Act. Let's get into this federal act and see why they should be, a quasi creditor should be paying the consumer twice the amount for any service that it was said to have performed. All right, and don't worry, these links will be in the description bar below. Okay, so you see there are a bunch of different things here, but we're going to get into the meat of some of these things. Okay, short title: Fair Debt Collection Practices Act. All right, congressional findings and declarations of purpose. There is abundant evidence of the use of abusive, deceptive, and unfair debt collection practices practices by many debt collectors. Abusive debt collection practices contribute to the number of personal bankruptcies, to marital instability, to the loss of jobs, and to invasions of individual privacy. Inadequacy of laws. Existing laws and procedures for redressing these injuries are inadequate to protect consumers. Available non-abusive collection methods means other than misrepresentation or other abusive debt collection practices are available for the effective collection of debts. Interstate commerce. Abusive debt collection practices are carried on to a substantial extent in interstate commerce and through means and instrumentalities of such commerce. Even where abusive debt collection practices are purely intrastate in character, they nevertheless directly affect interstate commerce. So, even if it's supposedly a creditor from within the state, like a state agency seeking to take take custody of a child that they have not just deposed who it was that made any sort of witnessing statements to any abuse or neglect of any child. Well, that's a matter of intrastate abuse, but nevertheless directly affects interstate commerce, because the people have the right to travel in pursuit of happiness. And if you don't like what the laws are in your county or your state, by all means move. And if you don't like the rules of the other state that you go to, move again. And if you realize that the nation that you're in is just like not the nation you want to be in, then consider expatriation or repatriation to another nation. I don't know. Once again, you as the viewer are advised to make your own adult decision. The presumption is already being made that the viewer of this information is not a child, is not a minor, meaning is of the age of majority and is competent to handle their affairs. And if you need assistance, by all means, if you feel you can't grasp it yourself, seek non-attorney services that might also provide referral services to lawful attorneys that can clarify these matters for you. Definitions are available, and I strongly encourage everybody to do a little bit of self-reflection and self-research and make their own determinations. All right. Acquisition of location information. Any debt collector communicating with any person other than the consumer for the purposes of acquiring location information about the consumer shall identify himself, not state that such consumer owes any debt, not communicate with any such person more than once unless requested to do so by such person, or unless the debt collector reasonably. And that's a little bit, when you understand what these rules are, like, the debt collectors seek ways to, have their consumer or their target consumer or their target debtor, comply or volunteer to repeat communications. So, like, yeah, you can communicate with me again through letter, if you're tired of getting phone calls, and if the you expressing that over the phone does not work, consider a cease and desist letter that, with a wet ink signature and possibly a notarization of your request for them to stop calling you and to only communicate with you by mail. Now, if you cease all communications, meaning whether through phone or email or through registered mail correspondence, then the only option that you're leaving that entity to, or that quasi collector to engage in, is to file a potential complaint and summons that may turn into a lawsuit, which, if you don't show up, like a traffic ticket, they will dismiss the case and charge you accordingly. So make sure you show up, even if it's just in paperwork form. Okay, communication in connection with debt collection. Like I said, at any unusual time or place, read this information. I don't want to take up too much of your time. All right, ceasing communication in regards to if a consumer notifies a debt collector in writing that the consumer refuses to pay a debt, or that the consumer wishes the debt collector to cease further communication with the consumer, the debt collector shall not communicate further with the consumer with respect to such debt, except to advise the consumer that the debt collector's further efforts are being terminated, to notify the consumer that the debt collector or credit may invoke specified remedies which are ordinarily invoked by such debt collectors or creditors, or, where applicable, to notify the consumer that the debt collector or creditor intends to invoke a specified remedy. If such notice from the consumer is made by mail, notification shall be complete upon receipt. If the consumer is denied for the purpose of this section, the consumer includes the consumer's spouse, parent, guardian, executor, or administrator. Because an estate also must be managed by an executor. All right? A trust for a spouse or an administrator of a trust. These are federal acts. These are federal laws. Laws that were made post U.S. Constitution. Whether that Constitution be 1786 or 1871, whichever one it is that you choose to recognize, here it is that you are whether you're physically free or still mentally enslaved or financially enslaved. These are the keys to unlocking those chains on your eyes, on your ears, on your mouth, and most importantly on your hands. Start writing. Start reading, listening, and writing. All right? Just the facts. Consumer bankruptcy filings. All right? And once again, the description of these links will all be in the description bar below. Don't forget to hit a like, the thumbs up button, and don't forget to subscribe if this information is assisting you. You want to help out, you want to give a donation, hit the thumbs up button. Just trying to hit 50. All right? Bankruptcy can provide a financial start for consumers who cannot pay their debts, either because of insolvency or insufficient income to meet creditor demands. Bankruptcy generally works in one of two ways: liquidating assets to pay one's debts under Chapter 7. You see the word assets. Assets pertain to what? They pertain to trust as well as estates, which are the deceased trusts. All right? So, bankruptcy court helps terminate fiduciary relationships. For those who are not familiar with fiduciary relationships, by all means, write these words down, please, ladies and gentlemen. This is not to be an insult to your intelligence. It is to inspire you to study and become competent in management of your own affairs. Okay, we can't await any messianic figures to come and say, hey, I'm going to do business and here's my business. By all means, if you're doing business with that individual or that entity, then be mindful and respectful of their service fees, as a workman is worthy of their hire. All right. Under Chapter 7 liquidation, a debtor generally can achieve a fresh financial start more quickly than under a Chapter 13 repayment plan, which can last up to 5 years. However, under Chapter 13, a debtor may be able to save a home from foreclosure, reschedule secured debts, and extend them over the life of a Chapter 13 plan, possibly lowering the payments or consolidate the debt payments to a trustee who then handles distribution to creditors. All right, so you can create a trust of your own, or you can await someone else to get involved and do that for you. By all means, you might want to just do it yourself. All right, lots of beautiful information on this webpage. I don't own or control any of the information. I'm only showing you just what's there. Okay, and let's go over here. Check out some some not so common articles, but before I get there, let me just show you one last bit of federal sourced information, because maybe you don't know where to start. Maybe you just need to submit your complaint, right? How can I submit a consumer complaint to the FTC? Who's the FTC? Well, that, my friend, would be the Federal Trade Commission. Come back from that ledge. Federal Trade Commission, protecting America's consumers. No, they don't pay me. And if they do decide to pay me, it's for that jingle. All rights reserved, intellectual property, so on and so forth. That much I do control. To report fraud, identity theft, or an unfair business practice, visit ftc.gov/complaint. Click on the FTC complaint assistant icon and answer the questions. The more information you can provide about the situation, the more useful your complaint will be. If possible, be prepared to provide. You can contact your contact information, name, address, phone number, email, the type of product or service involved. And for those of you who are not aware of what type of product or service that is involved, the product is credit. That is the product. The service involved, the extension of credit. All right? That's what those businesses are engaged in. Or the service of collections of debts. All right? So a company could be, they might even have in some, I've seen cases where people actually did owe certain amounts. But the way that the debt collector went about their process, it was a violation to the service. It wasn't filed timely. The responses were delayed, and it affected the consumer's ability to also gain any type of remedy that could have offset any debt. So now that potential consumer is now, well, not potential consumer, that consumer is now looking into forms of bankruptcy, to get a fresh start, because that is the discharge of debts court. All right. The more information about the company or seller, business name, address, phone number, website, email address, representative's name. Get the agent's name. Find out where the company is located, because once again, in regards to federal disputes, diversity of citizenship is a term that means that two parties reside in differing states. That is a matter that can or should be heard by a federal court. All right. And details about the transaction, the amount you paid, how you paid, and the date of which you paid. Now, I gotta say on this payment note that oftentimes, and I've seen this a number of times in the last couple of months, helping consumers with foreclosure disputes, that the amount being foreclosed on, or the amount in relation to the house or the property being foreclosed on, the consumer is never being credited as having made any payments. So like, even if the person made over $75,000 worth in payments, right? And they did that in, like, let's say like 7 or 8 months or a year, and here it is that this entity that has a transferred promissory note, or maybe they do hold the original promissory note, but they don't hold the original promissory note because that is the deed of trust between the buyer and the seller. And banks, as we all know, cannot hold, well, they cannot own any property, so they don't sell you property. They sell you, they sell you something that they were holding, right? But then they transfer that contract for the mortgage. That's what that is. That dead pledge of a dead entity. The bank is a dead entity. It's a straw man. It's a shell corporation, right? That is basically covering the assets of its creator or its grantor. Now, I might be confusing a lot of people with this language, so I would definitely encourage you to do a little bit more research before you start, trying to argue anybody down in any court or any venue, whether, even in and amongst yourselves. You know what I mean? Like, really, really, like, do some research. Get together, hold a study session. You know, it's free for you to study with your friends, and if you don't want to study, then you can study with me a little bit more. Via these videos, these free informational and educational videos. All right. If you are not able to view the video above, view the video here. And this video is on YouTube, just to let people know. But once again, the FTC accepts complaints related to many topics, including identity theft, national do not call registry violations, meaning you put yourself on a DNCR list, right, for advertisements and even possibly for debt collection of debts. But collectors violate that, and here it is that you're still getting phone calls at odd hours. Computers, the internet and online privacy, telemarketing scams, credit scams, immigration services, sweepstakes, lotteries, and private prizes, business opportunities and work at home schemes, health and weight loss products, debt collection, credit reports, and financial matters. All right. So that's pretty much all we got from that. And so we got there. And what we're going to do is we're going to view this NOLO's article right fast, and common violations and conditions of the Fair Act and the Fair Debt Collection Practices Act. All right. Files, furnishing and reporting inaccurate information, failing to follow dispute procedures. When you submit a written dispute about the accuracy of an item on your credit report, credit bureaus and your creditors must take certain actions in response. Their duties include conducting a reasonable investigation of your dispute, correcting any inaccurate or even removing the disputed debt from your credit report. There are a number of ways they can fall short of their duties, depending on whether they are the credit reporting agency or the creditor. Debt dispute violations by the CRAs, the credit reporting agencies, include failing to notify a creditor that you dispute the debt that it has been reported. Conduct a reasonable investigation of your dispute, or correct or delete any inaccurate, incomplete, or unverifiable information within 30 days of the receiving notice of your dispute. Debt dispute violations, and this is a slightly longer list, but don't worry, ladies and gentlemen, this is where we come to a close. Debt dispute violations by creditors and other information suppliers. Some common violations by a creditor or other information furnisher include failing to notify every CRA involved that you dispute the debt. Submit corrected information to the CRA subsequent to investigating your dispute. Refrain from continuing to submit information that it knows or should know is incorrect. Conduct an internal investigation of your dispute within 30 days or 45 days of you supplying additional information during the investigation. Provide you with a reasonable procedure, including an address to submit a written dispute or report of identity theft, or inform you of the result of its investigation within 5 business days after it completes the investigation. All right? Violations for privacy and withholding information and the remedies that you have available, all at your fingertips. So, ladies and gentlemen, thank you for joining me on this beautiful, beautiful Friday. To those who observe, happy holy day. To those who do not, love, truth, peace, freedom, and justice still is always extended to you. And to all things, as the Creator is in all things. For more information, feel free to shout me out at moorstemploliht@gmail.com. Donations are appreciated, but they are not mandatory.